So what happened?
He kicked in the door.
She said I kicked in the door.
And why is that a problem?
Because I'm in a wheelchair and have been for 25 years.
On the other side?
I literally can't. I don't have muscle control. I'm not. Oh my God. Oh my God.
Welcome back to Advocacy Alchemy with Professor Ross. Today we have a good one, guys. Our title says it all. Can a paraplegic really kick down a door in a wheelchair? We'll unravel a College Park, Georgia case where 43-year-old Charles Reed, paralyzed since age 18, was arrested on a burglary and assault warrant after allegedly forcing his way into an ex-girlfriend's home. The body cam we're about to watch, it collides with Georgia burglary laws, arrest warrant procedure, the Americans with Disabilities Act, and plenty of intuition. The same that's used to drive snap decisions in policing and courtroom rulings. So with that, let's jump in and let's take a look at this video. We'll start with the news report and then we'll look at a shortened version of the body cam when Mr. Reed came to the police station. Let's jump in.
News now at 7. A Metro Atlanta Police Department now under fire for how it investigated an alleged attack and home invasion.
So what happened?
He kicked in the door. I ran. He choked me out.
An Atlanta News First investigation uncovered evidence that that woman may have fabricated her story. Investigative reporter Andy Parati found it led to the arrest of a man who says he is innocent.
536, just confirming you're advising signal 20, front door.
College Park police respond to a home in June 2024.
Oh, thank God.
All right, how you doing?
After Catherine Jensen says her ex-boyfriend attacked her minutes before they arrived.
So what happened?
He kicked in the door. I ran. He choked me out. Tried to get the keys from my hand of my truck.
So he grabbed you by your neck?
Mm-hmm. Handling myself. I'm too small.
You say he kicked the door in?
He did.
Charles Reed is the man Catherine claimed broke into her home and assaulted her.
She said I kicked in the door.
And why is that a problem?
Because I'm in a wheelchair and have been for 25 years.
Oh, come there.
Charles cannot move his legs. He's paraplegic following an accident when he was a teenager. Andrew Fleischman is Charles' attorney.
She describes that he's of average build,
Tall, short.
Average height.
that he has brown hair, that he's in black clothing,
So all black.
I want to say yes, sir.
but not that he's in a wheelchair. Never mentions it. And that is probably the number one thing you'd mention about somebody.
Especially as they're running away.
On foot.
I guess he took off on foot.
Charles and Catherine did date, but it was more than 20 years ago. They never kept in touch. He's been married for a decade with a newborn. And the day of the alleged attack, Charles says he was at a dinner party with friends.
Did police contact you at all?
No, not at all. Not a single time.
You didn't get a phone call?
Not a phone call.
You didn't get an email?
Not an email. Not a visit.
No one questioned you about this?
Nope.
For 9 months, Charles says he had no clue officers had a warrant out for his arrest for aggravated assault until the federal government alerted him when he tried to renew his passport. So he emailed Officer McKinley Boletti and set up a time to meet at the police department last month.
Then I finally go up there literally knowing absolutely nothing about it. I essentially surrendered myself because I was that innocent.
According to the body camera video, Officer Boletti questioned whether he was actually disabled.
Unfortunately, you do have the warrant out for your arrest, so I'm gonna have to place you into custody.
Is this a joke?
Charles warned the officer putting handcuffs on would likely make him fall because of his paralysis.
I'm sitting there literally exactly like this in my chair. And so he handcuffs me and I'm like, hey, like just FYI, like I can't move.
I literally can't. I don't have muscle control.
It's too late.
Oh my God. Oh my God.
I mean, I could have broken my hip and died like very quickly.
How did they respond?
They literally sat there and just watched me writhe on the ground.
The officer still didn't believe Charles was disabled. Neither did his supervisor, who never put his eyes on Charles before saying this.
It's a ruse, man. So, I mean, it's an obvious attempt to not to go to jail, so.
A fellow officer disagreed.
Might need to call the district attorney's office. Because if the door was kicked in, he didn't kick it in.
Finally, Officer Belletti admits he could be wrong.
Because now it's looking like she might have made a false report.
He started to hurt me about March of this year, and
A year before Catherine claimed Charles assaulted her, the Noonan Police Department, about 30 miles away, arrested her for theft and forgery after allegedly filing a false police report claiming someone stole from her. Fleischman says officers have access to a state database identifying prior arrests, but Officer Belletti never mentions Catherine's arrest record in the incident report.
I've never seen a case where somebody was so clearly innocent and it would take so little work to establish it, and nobody was willing to do the work.
it was a tumultuous relationship.
According to this email obtained by Charles' attorney, Catherine wrote to a College Park police detective this week asking to change her statement, writing, "My mental state and physical trauma in that moment worked to confuse me. Please contact me at your convenience so I can edit the information in the report and clear the name of an innocent man."
How's this impacted you?
Well, I haven't been able to leave my house in a meaningful way in 2 or 3 months, just out of fear that I'll be picked up for an arrest warrant.
Has the police department apologized?
Not a single bit. Haven't heard a word from them. In fact, we've been trying to get into communication with them repeatedly, both me and my lawyer.
Because ultimately, that's all we're asking for, just to be adults. Take responsibility when you make a mistake and try to fix it.
College Park Police did not respond to repeated requests for comment about this case. We reached out to Catherine Jensen. She also did not respond, but her mother says she now acknowledges Charles did not attack her. Catherine has not been charged.
Officer Ballard, you're the one I've been emailing recently?
Yeah, all right.
Doing well. Give me a second. I'm gonna just read you something and then I'm gonna ask you a couple questions, all right? In your wheelchair.
Since I was 18.
Since you were 18?
5 years.
If you don't mind me asking, what's your condition?
Gunshot. I was robbed.
You were robbed?
Murdered. Yeah.
When and where did this happen?
In 2000, over by the pen.
By where?
By the federal pen, like Boulevard.
When you get murdered, because I'm talking to
I died on the table, and I woke up with my heart on the table in Grady. They told me I died. Control after the thoracic 3 vertebrae, right? So I have hand control. I got murdered when I was 18. I'm 43 right now.
Wait, what?
I was shot on the pavement, like on Moreland Avenue.
You just said
I died. Woke up in Grady with my chest splayed open.
Right. Oh my God. My location for a white male who fell out of a wheelchair. My bad, 24 to radio canal for signal 4 to my location. N35 lobby for a white male who fell out of a wheelchair. I was like, can you raise your hands? Because I'm trying to, pat him down, make sure he doesn't have anything. I don't know if the camera's gonna catch it, but I got him by the tip of my fingers. And he just, because you fell on the floor. So you have to be medically cleared before we take you.
Yeah, please.
Because first, he just fell down just now a couple minutes ago. And then just with this, him being in the wheelchair. Ag assault.
I broke into somebody's house.
From the trespass, ag assault.
How long due diligence? Because if you're paralyzed, somebody must have made a mistake.
Could kick anything, no offense, at this point in time. So, that's why I told you earlier, part, because that would be how he would have entered the home to do all of that. Conclusively prove that you can't force entry into a home. I'm gonna let you know right now, he just walked the hell out of that wheelchair. I held him with the tip of my fingers and he flopped down and fell on the floor. But
I cannot sit in a normal vehicle like that.
All right, Carl, can you have Grady come, please?
It's uncomfortable for me to be in any vehicle other than my vehicle. That's why it's a special vehicle with hand controls and all that stuff. In any chair, except for my chair, because I have severe scoliosis. I'm a teaching paraplegic. That probably means a lot to you guys. But me being in any situation other than this wheelchair, answer to it and talking to me, but I can't do it in a way that's gonna break my leg or break my hip or give me or give me an abrasion that's going to turn into a bed sore or things like that.
The back of the police car, which is a good firm hard seat. It's firm. The ride is
But basically on what day was this? I still remember the call. On June 15th last year, I got a call about a lady from 411 Fredericksburg Drive. And so basically she was like, and when I got to the house, the front door was kicked in, and I think she was like hiding by the garage or something. And she comes out and she's bleeding from her arm. Her neck is bruised up and everything. She's like, my ex-boyfriend who we broke up 2 days ago just entered my home and attacked me. And then, do you have any of his information? Gave me his name, spelled it out, gave me a description, told me what he looked like, ran it through NCIC, it matched. And then I was like, is this him? She was like, yes, that's him. Gentleman right there, issue the warrant. So now he's saying, man,
Really think about this and tell me some other information other than that. Clear mistaken identity.
we're attempting to accommodate
Can
you.
I just finish my statement? I'm very willing to answer to it and talking with you, but I can't do it in a way that's gonna like break my leg or break my hip or give me or give me an abrasion that's going to turn into a bed sore or things like that. I would love to deal with it. I've been trying desperately to deal with it for a month.
Go through the whole entire process, meaning getting booked in, taken to jail, going to your first appearance, and then you'll speak to somebody, they'll give you a bond, they'll schedule a court hearing, and then this is when I told you, bring all your documentation.
County, and then their judge in Fulton will go ahead and release you, make another court date, give you a signature bond, or do whatever they're gonna do. Our job is to take people into custody. So
Your name, spelled it out.
You went over there and talked to her?
She spelled it out and she described your appearance to me.
She said wheelchair?
She didn't say wheelchair, she just gave me your
recommendation, then my final recommendation is turn yourself in tonight around 3 in the morning. Come in the middle of the night.
Yeah.
That way it's almost the morning. They'll bring you in, book you in, they'll take your phone, and then you'll see the judge first thing in the morning. It's not a lot of time in between.
Right.
You won't even have time to sleep because it'll be to see the judge.
and you'll be in your chair so you won't have to worry about being uncomfortable moving.
No, we go get you. But we don't want to do that. We want
And
you
then
to
that
just
will be
turn
less
yourself
accommodating.
All right, let's view the charges and let's see what's at stake. First, you have burglary in the first degree. This is found at Georgia Code section 16-7-1. And it says if you enter and occupy a home with felonious intent, this carries a penalty of between 1 and 20 years in prison. And you have to ask originally, how is this possible? If Reed couldn't physically enter, then it's hard to bring this charge. Number 2, aggravated assault. This is found in section 16-5-21. It's defined as assault with the intent to murder, rape, rob, or assault done with a deadly weapon. This carries a penalty of between 1 and 20 years in prison. So it looks like Georgia has a very lengthy range they can go for on these different charges. Here we had no weapon, and we don't really have a motive for what's going on. So that makes reasonable doubt grow about this whole situation. Number 3, false report or a false statement. This is found at section 16-10-20 and section 16-10-26. This is essentially when you lie to the police or to the government. It carries a penalty of between 1 and 5 years and a fine of up to $1,000. This also could carry civil liability and will potentially allow Mr. Reed to sue her. Number 4, ADA Title II violations. It's important to understand that the police must reasonably accommodate individuals with disabilities, and that's even during arrest, transport, and detention. Now, this does carry some penalties, and those are money damages. They're called compensatory damages. You could also receive an injunction, which is basically an order from the court saying you must do something. If you fail to do something, you could be held in contempt, or you can be charged once again, another money penalty. There's also attorney's fees that are paid for, You wouldn't be able to get any punitive damages against the city, but the officer himself could be at risk, or any of those other officers who dealt with him. This type of action will be filed under 42 U.S.C. Section 1983. All right, number 5, a faulty warrant based on perjury. All right, perjury is once again knowingly or recklessly submitting a false affidavit that triggers a hearing. Perjury carries between 1 and 10 years in prison. Any evidence obtained from a bad warrant can be suppressed. One of the key things to take away from this is that due to a potential false report, Mr. Reed faces up to 40 years in prison if these charges were brought, if they were able to stick, while the complainant, the officers in the city, all carry major exposure if the facts don't line up. This all is really a legal minefield. Let's take a look at the evidentiary standards, because they still apply here, and it's questionable whether we get to probable cause once the officers put their eyes on this individual. So let's jump into those next. Remember, the evidentiary standards are important. We talk about them daily because without these standards, then police and lawyers wouldn't know how much evidence is required in order to get to trial and to succeed in either defending or for the state to achieve a conviction. There are 6 levels. Let's start at the bottom. First, you have mere suspicion. This is defined as a gut feeling or a hunch, but no articulable facts or evidence is available. Here, the officer's first glance at Reed's atrophied legs should have triggered an intuition that something was off. I should always warn you that acting on suspicion alone risks profiling and potential civil lawsuits. Number 2, reasonable suspicion. To reach this level, the police must have specific, articulable facts of possible criminal activity. Now, in practice, a 911 call plus a victim IDing someone specific gave cops reasonable suspicion to detain Mr. Reed if he had been on the street. Now, it's important to remember that any detention for the police to conduct an investigation should be brief, and it has to be narrowly tailored. And this goes for things like Terry stops, but doesn't apply to a full arrest. Number 3, probable cause. Now, this is defined as when the police or the government have enough facts to make a reasonable person believe a crime has occurred and the suspect is involved. Here, a magistrate signed a warrant based solely on the ex-girlfriend's sworn statement. Now, we saw later on that that might not have been the best move. It does bring a problem forward, though. Now, if the sworn statements are false or physically impossible, probable cause evaporates and the warrant fails at a probable cause hearing. It's important to remember that probable cause is a level where police can arrest a person, or they can go seek a arrest warrant or a search warrant. Let's move up to number 4, preponderance of the evidence. This is defined as having a higher than 50% likelihood that a person's claim is true. We usually say it takes about 51% of the evidence to prove that your claim is true. This is used in civil cases. This is the standard that's used generally in most civil cases. Now, if Mr. Reed files a lawsuit claiming that there's violations of the Americans with Disabilities Act, a jury would decide whether the city failed to accommodate him. The accommodation that we're talking about here is him being able to be transported in a way that won't hurt him. Let's move up one more. Number 5 is clear and convincing evidence. This is defined as having a high probability or a high likelihood that the claim is true. We usually say this takes about 75% of the evidence pointing to your claim being true. And it's enough evidence that the fact finder would be firmly convinced that your claim is true. Here, this standard will be used if there's going to be a potential claim for some punitive damages, which means punishment damages in a civil lawsuit. And this could be in one for the filing of a false report against Catherine Elizabeth. Understand that clear and convincing evidence is harder to reach than preponderance. Number 6, beyond a reasonable doubt. This is defined as when there's no reasonable doubt of the guilt of the defendant. This is the highest standard in the American legal system. Now, a prosecutor must persuade jurors that a paraplegic somehow forced the door and assaulted the victim. The key thing to keep in mind about jury trials: if even one juror thinks the physics say no, the verdict is not guilty. Or, to be clearer, the verdict could result in a hung jury, which leads to a mistrial. Verdicts have to be unanimous in criminal trials. That means everybody has to be going in the same direction. Okay, next let's think about this from the perspective of a juror. If you had to be on a jury for this case. Now, let's change our perspective. If we were in the jury box, and there's 12 of us, no one has a law degree, and we're sworn to judge the facts and the credibility of the witnesses. Let's talk about the visual impact first. A man rolls in the court in a wheelchair. His legs are visibly atrophied. Now, an ordinary person should ask first, would it be possible for him to even kick a door down? I understand that that question itself has some emotional weight. Sympathy rises, but also we become skeptical. Why would anyone accuse a person who can't walk of kicking the door down? Let's move on to our next question. You have the whole storyline that's been given to us. We have the victim saying that this is her ex, Charles Reed. You have a door that's actually kicked in. Got a woman with a bruised arm and some bruising around her neck. And we have a 9-month-old warrant signed by a judge. Now, in modern times, we ask questions like, well, where's the ring cam video? Or were there any fingerprints, shoe prints, or wheelchair tracks close by that we could see? Or even did the victim get looked at by EMTs and what they say about the injury? Now, how about if this did come to trial and the defense put on information about his, Mr. Charles Reed's, medical condition, that he has 0 leg function since the age of 18, or it showed that his wheelchair doesn't allow him enough force to destroy a door or kick in the door, or simply that he had an alibi for where he was on June 15, 2024. When you have a case like this, you'll have people that usually sit somewhere between two extremes. One extreme is that if the person was arrested by the police, they must know more. The total opposite is, isn't it abusive to arrest a man in a wheelchair without any further proof? Now, this could be handled through a process called voir dire or voir dire, but this is a process where you ask the jurors questions and have them respond back. And the focus is to wean out the people that you want to be on your potential jury. You want people that are going to fall close on your side, but there's an understanding that extremists on either side are going to be kicked out of the potential jury pool. All right, so with that, let's move into our final word and let you all go for today. I can give you an overview in 3 beats. Number 1, the law. Reed faced 40 years on burglary and assault, but only if the facts can really hold up. Number 2, the evidence. Evidence must climb from a gut hunch all the way to beyond a reasonable doubt. If we miss any steps in between, this case potentially collapses. Number 3, common sense. Here we had a paraplegic kicking a door down. It's not possible. That simple observation should ring all types of alarm bells. Now, the biggest point, officers meet plenty of actors, fake injuries, fake tears, fake stories. A healthy amount of doubt is important and part of policing. But doubt cuts both ways. When anatomy and accusations clash, slow down, verify, and document everything. Sometimes common sense is the best body cam in the room. Now, let's end up by asking ourselves this. If they just did a 2-minute medical check, or if they looked for tire tracks, they might have saved hours of investigating and potentially a lawsuit. Now, how do we balance caution about people being liars with the respect for what we actually see and know to be the truth? Tell me what you think in the comments below. Hit the like button. If you believe common sense still matters, smash the subscribe button and hit the bell. Remember, this is Advocacy Alchemy and I am Professor Ross. I'll see you tomorrow. Everyone have a great day and stay safe.